This is your podcast for Section 7. And if you've taken a look at the syllabus lately, this is the section where we review or have a final review of direct, circumstantial, and physical evidence. As part of that review, I've asked you to do a couple things. One, to, in your own words, summarize the difference between those three things. And then second, find a case that's recent, within the last 5 years, an Illinois criminal case that discusses one issue with direct evidence and one issue with circumstantial evidence. If you need to find two cases to cover both of those, find two cases. It's highly likely, depending on how much time you put into it, that you can find a case that discusses both an issue with direct and an issue with circumstantial evidence, or discusses direct and circumstantial evidence. As always, I want you to provide a good in-depth summary of the facts and issues of the case, the court's analysis, and its decision on both the issues of direct and the issue of circumstantial evidence. Remember, the facts of your case are very important, and the application of those facts to the issues and then the court's analysis of the rule of law is what tells us how a particular thing applies to a particular circumstance, the unique circumstances of the case that you're presenting. I also caution and canvass that I want you to tell me what you believe, not what you feel. We don't feel in the law. Evidence and the authority of the law and how we deal with evidence and the authority of law and justice are without feelings. It's just the facts. It's the law. It's the application of the law to the facts that tell us how a particular issue should be dealt with. And I also ask you to tell us if you believe that the court in your case was correct or incorrect in its decision, and then tell us why. Again, not what you feel or that you feel it's wasn't a good decision. And you'll see people write that. I didn't feel the court was. No, it's not feel. It's I don't believe that the court was correct here because this is what the law says. This is what the issue was. This is what the facts were. And this is how the law should react or apply to these facts on this issue. So we've discussed the jury instructions that a jury receives in a civil or criminal case, but in particular a criminal case for the research that you're going to do this week. And the Illinois pattern jury instructions treat direct and circumstantial evidence as having equal weight. If you go back and review what you learned in the early weeks of the course, we focus on the weight and credibility the jury assigns rather than the type of evidence. And the pattern jury instructions for Illinois tell us that direct and circumstantial evidence are to have equal weight. So the jury is instructed by the judge to give direct and circumstantial evidence equal weight. One is not better than the other. Now, physical evidence, exhibits, and witness testimony are considered along with reasonable inferences to establish facts beyond a reasonable doubt. Some of that physical evidence and some of that witness testimony is direct, and some of it is circumstantial. And again, it has equal weight, but it's considered along with reasonable inferences to establish facts beyond a reasonable doubt. That's those dots I talked about over the various weeks of the course, and probably you've heard me in other courses talk about connecting the dots of evidence, connecting the dots of circumstantial or direct evidence to get to that point where, in a criminal case, a jury can um, consider all of that evidence to establish facts beyond a reasonable doubt, or determine that the facts were established beyond a reasonable doubt. Or in a civil case, it's preponderance of the evidence. To review what that means, in a criminal case, if you hold your hands up, palms pointed upward, hands to the side, about shoulder height, and you take your right hand and raise it as high as you can go and your left hand as low as you can go, that's what the scale of justice looks like. That's what the jury is supposed to come to and weigh in the evidence when they find beyond a reasonable doubt. That scale is tipped as far as it can go. Now, the burden of proof in a civil case, if you go back and have your hands, palms facing up, shoulder height just outside your shoulders, and you bring that left hand up just a little bit and your right hand down just a little bit, now your scale has tipped just a bit. That's preponderance of the evidence. Civil cases have a lesser standard of proof. Preponderance of the evidence just requires that scale of justice tip just a little bit. Whereas a criminal case beyond a reasonable doubt standard requires that scale of justice tips a lot, almost all the way, very close to or at all the way. There's no doubt. Why do we have the higher standard? Because in a criminal case, your life or liberty is at stake. And in a civil case, it's property, it's damages. Nobody's going to prison, nobody's going to lose their life. So direct evidence in Illinois is evidence that proves a fact without inference, with nothing else needed, such as an eyewitness testimony or video recording of what occurred. If you took criminal law, you probably had a project where you watched a video of an actual criminal occurrence, and then you wrote a report on that occurrence as if you were a police officer. And that's what I typically use, something like that as the final project for criminal law when I teach criminal law. That's direct evidence. It's the camera catches it, the video recording is what you're watching, it's directly what happened. Circumstantial evidence is proof of facts and circumstances that allow the jury to infer other facts. Again, if you go back to that final in criminal law, whatever version that you participated in, you saw circumstances that weren't exactly direct evidence, but they allowed you to infer what likely happened. And the jury then would be able to hear that testimony when you testified as the police officer who reviewed the video surveillance and then was there at court to report or to testify as to what you saw. Physical, sometimes called real evidence, are tangible items. Those are fingerprints, weapons, documents. Now, they can be direct. Physical, real evidence can be direct. For instance, the surveillance footage of the act that I discussed a minute ago, or circumstantial, finding the defendant's fingerprint on the murder weapon. That's direct evidence that the defendant held or touched, possibly had possession of the murder weapon, it's not direct evidence that the defendant committed the murder. It's circumstantial, right? And with more evidence, you know, gunshot residue on his hands. Somebody saw him fire the weapon at the victim. With more circumstantial evidence or more direct evidence, other evidence to connect the dots, it could be used by the jury. Now, the Illinois pattern jury instructions tell us that there's no distinction between the weight to be given either direct or circumstantial evidence. The jury instructions tell us that the jurors are instructed to use reason, experience, and common sense to draw inferences. Okay, reason, experience, and common sense, if you remember our prior discussions about the jury instructions. And as to burden of proof, both forms of evidence are used to meet the prosecution's burden of proving guilt beyond a reasonable doubt in a criminal case or the plaintiff's burden of preponderance of the evidence in a civil case. The court instructs the jury to consider all evidence, direct or circumstantial, including testimony, exhibits, stipulations, and judicially noticed facts. And that all occurs at the end of the case before the jury gets the case. Again, I use the time as a little commercial. If you ever get the chance to go and sit and take in a trial, criminal trial, go do it. And I know you can watch them on TV, but being there physically in the courtroom, and sometimes, there's a lot of delays and so forth. It depends on how sensational the case is. And if you call the clerk's office and you ask and you explain, I'm a student and I'd like to watch a criminal case, they will definitely tell you what cases you are going to be held or what trials are coming up. Typically, the people at the courthouse are very helpful in telling you things that you'd like to see and facilitate you getting a seat. Sometimes you get to meet the players, the state's attorneys, the defense lawyers. If a judge finds out you're a student because you're sitting in there observing the courtroom, some judges have in the past taken students, introduced the students to people, and helped the students understand what was going on. It's a great opportunity, and the courts are open to you as long as it doesn't include a juvenile or a child issue. And I've said this in many ways, in many forms over the course of the semester, but you have to appreciate the importance of evidence. You have to understand and distinguish the issues relevant to circumstantial evidence as opposed to direct evidence, and recognize that each of these categories of evidence possesses, in theory, equal force and weight before the trier of fact. Proof of a fact may be made with either direct or circumstantial evidence or both. And a lot of times it is both, and a lot of times it is more circumstantial than direct. A conviction may similarly rest entirely on circumstantial evidence as long as the body of circumstantial evidence has been sufficiently connecting those dots to meet the legal standard of proof beyond a reasonable doubt in a criminal case. And as the cases for this week should indicate, connecting the dots require that you complete your investigation and fact gathering as police, that the presentation of those facts and evidence as prosecutors be connected clearly in order to get by objections, and we do our job to the best of our abilities, leaving no stone unturned. Students who had me for a civil litigation course know I like to refer to it as being the shop vac in a civil case when you're going out there to do an investigation as a lawyer or legal assistant or paralegal. You're going out there and you're trying to gather every single speck of potential evidence. And if you've ever used a shop vac, you suck up all the mess that you created that you need to sweep up, and then you can dump it out and sort through it. See if there's anything that's usable or worth salvaging. You want to be complete in your investigation, no stone unturned. Now, real and physical evidence is that evidence that's addressed directly to the senses, such as sight, hearing, touch, taste. It's tangible. That means it can be held. Real physical evidence involves the artifacts of the scene, the items that indicate the history or circumstances of events, items like a gun or a piece of clothing, blood on the area of carpet, a hole in the wall made by a projectile, a bullet. When a lawyer introduces an item of real evidence with no historical connection to the crime, that item is most likely offered for demonstrative purposes, to demonstrate. For instance, a knife similar to the one used in the crime as opposed to the knife that was actually used in the commission of the crime is called demonstrative real evidence. Because of its nature, real evidence may prove to be more persuasive than oral or documentary evidence, but it still has to pass admissibility tests. Some of these tests are unique to real evidence, and as with all evidence, real evidence must still pass the usual hurdles of relevancy, materiality, and competency that we learned about in the early weeks of this course. Some of you are going to appear on the scene as police officers, and your first job is to preserve evidence, preserve the scene. If you get the chance to complete an internship, if you're a law enforcement or criminal justice student, either here or wherever you transfer to, if you transfer, you may get to see firsthand and likely will get to see firsthand the process of preserving the scene. I don't have the internships students currently, but for over 20, whatever, close to 30 years, I had those students, and several times students were called to or were with an officer called to a scene that they had to help preserve. I remember one case in particular, a well-known public figure locally had passed away and was found decomposing in his residence, and a student called me because they were freaking out because they were stationed at the door to this structure where the body was found and told not to let the press in. And so they were standing there until other people arrived because they were the first to the scene. That officer that they were with was trying to preserve the scene, so that officer had gone to the area where the body was located, making sure that nothing or nobody or nothing else was in there, and then they secured the scene until other people came and command officers came and they started to decide how they were going to address and proceed with the scene. So when you're the first person to arrive at the scene, you do that. You preserve the scene, you keep it secure. And then others will arrive to analyze the evidence and process or secure the evidence and gather it, process and present the evidence for court purposes later. we always keep in mind what our role is. So there's the people that arrive first at the scene, there's the people that arrive who are going to handle the investigation, the detectives. There's the people from the crime scene unit that are going to come to preserve and process the evidence that's at the scene, secure and gather that evidence and process it. And then everyone at some point is going to be called to testify if it goes to court and a trial, and they'll help present what that evidence was in their particular role. When you have those roles, you have to keep in mind what your role is and what the law is related to your assigned task. What you do and how you approach your job could very well help or hinder the investigation and subsequent arrest or attempt at conviction. And you'll see that in the various cases and things that you look at related to this week's topic. You're likely in your cases this week to see discussions about chain of custody and the ability to authenticate evidence, things we've discussed in the past. Those issues exist in every form of adjudication, hearing, trial, civil or criminal. Those are the items that we set as some of our foundational blocks many weeks ago now. For people who are going to go into law, lawyer, paralegal, legal assistant, it's imperative that you are sure the chain of custody exists and you line up the testimony necessary to allow evidence to be presented and that chain to be authenticated at trial. The same goes true for people entering law enforcement and criminal justice fields. It's imperative that you keep a consistent process for collection of evidence, storage of evidence, transporting evidence to the courthouse, and then keeping the evidence safe and secure during a trial. Being prepared to authenticate the chain of custody of evidence, as in all reports, documentation, and then narrated through testimony, is key to that solid case and the pursuit of justice. In criminal cases, this is the most frequent and important issue regarding evidence you're going to encounter day to day. We collect evidence at the scene. It needs to be properly kept, properly secured, properly noted, sealed, put in a safe place that is only accessible by a process that indicates who accessed that evidence and for what purpose and when it was returned and all in between, where it went, who touched it. So you need to know the law, know the procedures that were developed in your office or agency to meet the expectations of the law and carry out your respective duties accordingly. If you do that, you'll never end up losing a case on that basis. In closing, I think it's just very important that we come back and we review direct and circumstantial and physical or real evidence, and that you, by now, accept and own what should be really a mastery of your understanding of these things. We set these as part of our foundation in this course early on because they're the foundation of most of the things that we will ever do in the law, criminal or civil, related to evidence. Evidence are facts. Facts are the basis for a criminal charge. Facts are the basis for an arrest, for probable cause to go up to somebody to determine if they need to be arrested, to make a stop. Knowing the difference between direct and circumstantial and physical evidence, how the weight of evidence applies, inferences, the burdens of proof, and all of that should at this point be second nature to you. And my hope is that this review is going to help you really solidify that so you can carry that forward, not just to the end of this class and not just to the next class or the next degree, but through your career. It's something that by now should be embedded in your brain, so it just becomes something that's second nature. It's part of you. We only have one more section of the class, so I hope you keep your energy up. I hope you do your best effort in this section. You finish strong, and I hope that you appreciate that the effort that you put into learning what you've learned in this class is going to serve you for a long time. And I hope that you share with me how it's serving you for a long time. I hope I'm around to see that. In the interim, if you need me, you know where to find me.